The opinion in number 77-178, Robertson v. Wegmann, will be delivered by Mr. Justice Marshall.
This case is here on writ of certiorari of the United States Court of Appeals for the Fifth Circuit. Clay Shaw filed a civil rights action against New Orleans District Attorney Jim Garrison and others involved in the prosecution of Shaw for his alleged role in the assassination of President Kennedy. When Shaw died before trial, his executor sought to be substituted as plaintiff. The district court allowed the substitution, holding that Shaw's action did not abate on his death. Because Shaw was not survived by one of the close relatives specified in the Louisiana survivorship statute, the court recognized that his action would abate under state law. But the court refused to apply this law and instead created a federal common law rule of absolute survival of civil rights actions. And the Court of Appeals affirmed. By an opinion filed today with the clerk, we reverse the Court of Appeals. Under 42 United States Code, Section 1988, we are required to apply the state survivorship statute to a civil rights action unless the statute is, quote, inconsistent, end quote, with federal law. We can find no such inconsistency here. The application of Louisiana statute will have no independent adverse effect on the policies underlying the civil rights laws, and we cannot hold that the statute is inconsistent with federal law merely because it would cause a particular action to abate. Mr. Justice Blackmun has filed a dissenting opinion in which Mr. Justice Brennan and Mr. Justice White join. I also have for announcement opinion in number 77-380, Andrus versus the Charlestone Stone Products Company. This case comes to us on writ of certiorari of the United States Court of Appeals for the Ninth Circuit. And the question is whether water is a locatable mineral under the mining law of 1872. The Secretary of the Interior challenged the validity of respondents' mining claims. Administrative boards held most of the claims invalid. The district court reversed and, among other rulings, granted respondent access to water that it had discovered on one of the claims. The Court of Appeals affirmed, adding sua sponte, that the claim with water was made valid by the presence of the water. By an opinion filed today, we reverse the Court of Appeals. A mining claim is not made valid merely because a substance discovered on the land is, quote, a valuable mineral, end quote, within the dictionary definition of these words. It is clear from the mining statutes that private water rights on federal land are to be governed by state and local law and custom. Administrative decisions and decisions of this court confirm this view, which is also supported by consideration of the practical problems that would arise from having two overlapping systems for acquisition of private water rights.
Thank you, Mr. Justice Marshall. Mr. Justice White will announce the judgment and the opinions of the court in 76-1114 California v. Southland Royalty Company in two related cases, and in Zurcher versus Stanford Daily and a related case.
The first three cases, the California against Southland and two consolidated cases, raise issues under Section 7 of the Natural Gas Act. Under that section, the consent of the Commission, now the Federal Energy Regulatory Commission, is required for the abandonment of any service rendered by certificated facilities carrying gas in interstate commerce. The question in this case is whether, upon the termination of a lease under which the lessee has made certificated sales in interstate commerce, the lessor must secure the consent of the commission to terminate the interstate sales. The Court of Appeals for the Fifth Circuit said or held that the commission had no power at all in these circumstances. We disagree and reverse the judgment of the Court of Appeals for the Fifth Circuit. As we see it, Section 7 does reach a situation such as this, and the consent of the commission must be obtained. This result, we think, is required by our cases, particularly Sunray Mid-Continent Oil Company case in 364 U.S. We accordingly reverse the judgment of the Court of Appeals. Mr. Justice Stevens has filed a dissenting opinion, and the Chief Justice and Mr. Justice Rehnquist have joined Mr. Justice Stevens. Justices Stewart and Powell took no part in the consideration or decision of the case. The other announcement I have is, as Justice Brennan indicated, is Zurcher against Stanford Daily, number 76, 1484, and Bergna v. Stanford Daily, number 76, 1600. These cases are here on writ of certiorari to the Court of Appeals for the Ninth Circuit. Under traditional Fourth Amendment law, the Fourth Amendment has permitted warrants to search property on which there is probable cause to believe there is located fruits, instrumentalities, or evidence of a crime, regardless of who owns the property. We are now asked to reconstrue the Fourth Amendment and to hold for the first time that when the place to be searched is occupied by a person not then suspected of a crime, that only in the most unusual circumstances should a search warrant be issued. Rather, it is suggested a subpoena ducis tecum should be employed. This was the holding of the district court, which was adopted by the Court of Appeals. We declined to adopt this rather sweeping revision of the Fourth Amendment, and accordingly have filed an opinion disagreeing with the Court of Appeals in this respect. The lower courts also held that whatever the rule might be generally with respect to so-called third-party searches, where the third party isn't suspected of crime, that a search warrant should not issue, but a subpoena ducis tecum should be used when the third party is a newspaper. That is, when the premises to be searched is occupied by a newspaper. We also disagree with this narrower holding, and as in our view, whatever First Amendment considerations there might be in a situation like this can be satisfactorily accommodated by a careful application of the usual criteria governing the issuance of search warrants. As I say, we do reverse the judgment of the Court of Appeals for the Ninth Circuit. Mr. Justice Powell has filed a concurring opinion. Mr. Justice Stewart has filed a dissenting opinion, and Mr. Justice Marshall has joined him. Mr. Justice Stevens has filed a dissenting opinion. Mr. Justice Brennan took no part in the case.
Justice White, the opinion and the judgment in 76-1608 Michigan v. Tyler will be announced by Mr. Justice Stewart.
This case is here by reason of the grant of a writ of certiorari to the Supreme Court of Michigan. The respondents, Lauren Tyler and Robert Tompkins, were convicted in a Michigan trial court of conspiracy to burn real property in violation of a state criminal law. Various pieces of physical evidence and testimony based on personal observation, all obtained through unconsented and warrantless searches and entries by police and fire officials onto the burned premises, were admitted into evidence at the respondent's trial. On appeal, the Michigan Supreme Court reversed the convictions, holding that the warrantless searches were unconstitutional and that the evidence obtained was therefore inadmissible. We granted certiorari to consider the applicability of the Fourth and 14th Amendments to official entries onto fire-damaged premises. For the reasons set out in the written opinion of the Court filed with the clerk this morning, we hold that an entry into a building to fight a fire requires no warrant, and that once in the building, officials may remain there for a reasonable time to investigate the cause of the fire. Thereafter, additional entries to investigate the cause of the fire must be made pursuant to the warrant procedures governing administrative searches. Evidence of arson discovered in the course of these investigations is admissible at trial, but if the investigating officials find probable cause to believe that arson has occurred and require further access to gather evidence for a possible prosecution, they may obtain a warrant only upon a traditional showing of probable cause applicable to searches for evidence of crime. These principles require that we affirm the judgment of the Michigan Supreme Court ordering a new trial. Mr. Justice Blackmun has filed a separate statement joining the judgment and most of the opinion. Mr. Justice White, joined by Mr. Justice Marshall, has filed an opinion concurring in part and dissenting in part. Mr. Justice Stevens has filed an opinion concurring in part and concurring in the judgment. Mr. Justice Rehnquist has filed a dissenting opinion, and Mr. Justice Brennan took no part in the consideration or decision of the case.